Welcome, and thank you for joining us for Conversations with Ted. My name is Gail Holtzman. I'm an attorney at Taylor English, and I have been representing employers in all aspects of labor and employment law for nearly 40 years. I had the pleasure and honor of clerking at the National Labor Relations Board in Washington, D.C. So we're going to be talking about some of the issues under the National Labor Relations Act today. I served as chair of the Labor and Employment Law section of the American Bar Association of Labor and Employment Law section, and really look forward to talking to you today about a very important development in the law. And with me today is my partner, Peter Spanos. Peter, please introduce yourself.
I'm Peter Spanos. I'm also a partner at Taylor English in the Atlanta area, and I'm also in the Labor and Employment Department. I've practiced all aspects of labor and employment, covering the entire employee-employer relationship since 1976 on a national basis. And one of the things that I do is labor relations involving the National Labor Relations Act, the NLRB, union organizing, collective bargaining, unfair labor practice charges, and things that fall under labor relations. It's a pleasure to be here.
Okay, well, thank you, Peter. So today we're going to discuss a very important development under the National Labor Relations Act, the McLaren Macomb decision that came down very recently. So Peter, I'd like you to just share with us kind of what an overview of this case and what it means. I know there have been a lot of reverberations within the employer community about what this case will mean and the significance.
It's a very important case, and it's important not only for its own content, Gail, but also for what it means in terms of the NLRB's orientation and what might be expected in the future. Focusing on the decision itself, the McLaren-McLean decision involved a hospital that entered into severance agreements with a number of former employees. Unfair labor practice charges were filed, which included alleging that very typical broad form confidentiality agreements and non-disclosure agreements under which the employees would not talk about their severance with other employees and would not talk about the company or disparage the company after their employment was terminated, the kind of clauses you often find in severance agreements. Those clauses were attacked by the General Counsel's office, which brings the case, of course, as violating the employee's Section 7 rights. Section 7 rights include not only the ability to organize and to bargain collectively through unions, but also to engage in what's called protected concerted activity for mutual aid and benefit. And the NLRB General Counsel argued in the case that these clauses, because they were broad, restricted unlawfully the employee's right to criticize their employer or to talk about things that they had problems with their employer. This is contrary to the law as it was at the time of the case was filed, because up until then, the law had been, since at least not 2020, that broad clauses like this were okay unless the employer committed other unfair labor practices related to violating employees' Section 7 rights. So in the McLaren decision, the NLRB held that merely asking employees to sign these broad form confidentiality provisions was an unfair labor practice because the employees could believe that they could not exercise their Section 7 rights for mutual aid and protection if they signed these clauses. The definition of Section 7 rights under the current NLRB is expanding somewhat, and this is an interesting case involving that. So it casts question into a practice that's been fairly common, and it's been getting a lot of press because of that.
Can you advise regarding kind of the scope of this ruling?
The ruling doesn't affect things that are intended to protect company proprietary information, trade secrets, or designed to restrain an employee's ability to go to work for a competitor, like a non-compete. It also doesn't affect non-solicitation clauses. It would affect things in not only severance agreements, but also in initial employment agreements, or for that matter, offer letters. There are 3 exclusions where the decision does not apply. And that's because under the National Labor Relations Act, there's a more narrow definition of an employee than under, for example, tax law or Title VII. Employees under the National Labor Relations Act do not include supervisors and do not include independent contractors. And that's in the statute. So what this means is this decision does not affect severance agreements or other agreements with these kinds of clauses with top executives, managers, supervisors, or independent contractors. It doesn't apply to anyone who has that kind of managerial authority.
Are there things that an employer can do without resulting in an unfair labor practice charge?
I think that there are, although the dimensions of it and how to do it remain to be explored. This decision is only a couple of weeks old at the time of this recording, and none of this has been tested as yet. But the key is to understand that not everything covered by a non-disclosure or confidentiality agreement is a Section 7 right.
What about the non-disparagement provision? Are there things that an employer can do with regard to that section of an agreement to protect itself?
There again, the question would be how to carve out the legitimate exercise of Section 7 rights, how to allow the employee to talk about the employer with other employees, or if they're former employees with, as a former employee, which may be protected under Section 7.
Would that involve, Peter, working on a definition of non-disparagement?
It would. You'd want to look at the definition from both sides. What is non-disparagement? What is confidentiality? And also, what are Section 7 rights?
Do you think we're going to get some additional guidance, rules, or other cases that will provide some additional guidance on how to proceed?
There's no question there will be other cases, because the scope of a carve-out or a exception to the confidentiality and non-disparagement provisions would be, it's people are going to have to explore that, and there surely will be cases.
And Peter, what are the penalties for a violation?
Well, the penalties for a violation include, in this case, striking all that language from the agreements and forcing the company to promise that it will not include that language in any future agreements.
Are there steps employers should take to make sure that if certain provisions are stricken, that the agreement is still enforceable?
The employer should include a savings clause that says that if any part of the agreement is held to be unenforceable, that the rest of the agreement can be enforced. And in states that would permit what's called blue penciling, where you can revise a clause, the employer could ask for and argue that the clause should be interpreted not to include Section 7 rights and effectively rewritten. But since it's in the NLRB, and given the opposition of at least 3 members of the NLRB, they probably won't rewrite a clause, but they would have to respect a savings clause and preserve the remainder of the severance agreement for whatever benefits it may provide for the employee and the employer.
It's really important that employers be proactive, talk to their labor council regarding what to do with these agreements, whether the agreements need to be revised and how they need to be revised to ensure that there's compliance given this very changing area of the law. Would you agree with that, Peter?
Absolutely, Gail. I agree. This is not a situation where you can wait for something else to develop. I think many people are wondering what this means for the future. And one thing that we can say is that this is a really good example of how the current General Counsel for the National Labor Relations Board and the current members appointed by the administration have been successful in changing the law to the way they think the law should be, as opposed to the way it was before they took their current jobs. This case directly overrules 2 prior cases. And as I said before, under those cases, these kinds of terms, confidentiality and non-disparagement, these kinds of terms were considered lawful to offer unless there were circumstances showing there was some kind of employer action intended to affect such an unfair labor practice, employee rights. So this is a great example of how a plan to change the law by bringing cases and then getting favorable decisions is working. And if you remember, from August of 2021, the General Counsel announced some 50 areas, 50 past decisions or groups of past decisions that she felt ought to be changed. Well, this is one that has been changed.
Okay. Well, thank you so much, Peter. And thank you out there for watching Conversations with Ted, focusing on this very important development under the National Labor Relations Act, the McLaren decision. Peter, you've really enlightened us regarding what the case means and what employers should do to ensure compliance. Very, very helpful advice. So if anybody has any questions or needs legal advice, you can find our contact information on the website for Taylor English, and we appreciate your time today. Thank you.